All right, so our next panel is intended to give you a view from the trenches here. So we hope that they're going to provide a view of our IP system from the perspective of corporations and entrepreneurs. And our moderator for the panel is Bart Showalter. Mr. Showalter is a partner and firm-wide chair of intellectual property at Baker Botts. And please join me in welcoming Mr. Showalter.
Okay. Thank you, Keith. Okay, so yeah, this is in the trenches. So this is what we want to do is really, we've heard a lot about theory and policy and the system and some of the law, but now we want to talk to some entrepreneurs and some real users of the patent system. So the two panelists that I have, to my far right is Hervé Févier. I think I said that right, pretty close. He's French originally, but right now he's been in Dallas for quite some time. He's a Texan now. He serves currently as Executive Vice President and Chief Strategy Officer for Xterra Communications. Folks may remember or know of Xterra. But Hervé goes all the way back to getting a physics and engineering degree from École Centrale de Paris, which must be in Paris, and then a PhD in physics, and did a lot of engineering, 17 years with Alcatel, doing product development and then getting into management roles, and was on the business side and was actually the VP and the general manager for optical networks for Alcatel USA, which is a pretty big job. Did that for a while, and then in 2000 he joined Xterra, which is a Dallas company, very cool company that develops some really awesome technology, and we're going to have Hervé go through sort of the history of that company. And so currently that's what he's doing is working at Xterra, has lots of tie-ins into the patent system. He says that his first patent application he filed in February 1984, and his last one he filed a few weeks ago. So heavy user of the patent system, lots of great insight. So that's our first panelist. And then our second panelist is Brendan Mills, and Brendan is been a good buddy of mine and a client of mine for a lot of years. And Brendan and I have been through the wars several times, many times. We're continuing the wars. He currently serves as a CEO and managing partner of Fortress Solutions. But before, and the first time that Brendan and I really spent a lot of time together was when he was CEO and founder of General Bandwidth. General Bandwidth is a company that Brendan started in Austin with two people. I think the first time I met with Brendan, we had 3 people in the meeting and only 2 chairs. And then that's grown into a really significant telecommunications company. And Brendan was the founder in 1999, took them through a number of finance raisings, 7 Rows, and many other important investors. And the company is still blowing and going. But in 2005, Brendan is a serial entrepreneur. He went ahead and started another company. And the name of that was Ripcode. And he sold Ripcode in 2010, and now he's on his third company, and that's Fortress Solutions. So one of the things that's cool about Brendan is he's got a really different perspective about patents and how they're important in different industries and for different companies that he's been involved in. And so I think that'll be a great perspective as well. So I'm going to stop there, and then I'm going to have the people that you really want to hear from talk a little bit more about their interactions with the patent system. I'll start with Brendan, where they can kind of go through historically what they've been, what hat they've worn in dealing with the patent system, and then we'll get into some discussion topics. Brendan.
Thanks, Bart. Appreciate it. I actually have a long history of dealing with patents. I actually grew up the son of a patent lawyer, so I was he used to take me to Washington, D.C. for business and drop me off the patent office to look at patents while he worked. So I've been involved with patents all my life in one way or the other. My first patent was when I was 13 years old. My father helped patent a gerbil invention.
I think it was a wearable habit trail.
I think so, something to that effect. I'm not sure wearable, but
maybe not.
Something. In any case, I'm a serial entrepreneur. I've got really 25 years of experience with startup companies. My first, I guess, real engagement with patents as a startup guy was at a company called NetSpeed. I ran product marketing for NetSpeed. We made DSL equipment, which is the technology used for broadband to your home today. And back in the 90s, we developed some unique capabilities around that technology, and we started patenting those. So we had several key patents, and I was very involved in kind of the creation of those, and then later started a company called Genband in 1999. At Genband, I think there were, it's hard to remember, but 5 or 6 patents I participated in. And it's now been 16 years, I think, since the first patent I wrote. And I'm actually in a trial regarding 1 or 2 of them right now. So it's a very interesting experience to come full circle to having dealt with those patents early on and now being engaged in some litigation 16 years later with those. So every company that thereafter that I was involved with, patents were a big part of our defensive strategy to protect our key inventions. And so in every startup that I was involved in, we always had a training early on, even in as little as 3 or 4 employees, on patent disclosures and proper note-taking, and making sure that early on that we budgeted for some very key patents early on. And it's hard to ascertain at that point when you're doing a startup whether that's actually going to be useful to you. Sometimes the patent process is so slow that it doesn't, the technology outpaces it by the time that the patent is actually filed. The market's moved well beyond it. Sometimes you're really early. Sometimes it takes 16 years for the patent to catch up with you, as it is for me right now. So it's always interesting to go through that process, but it's definitely been useful to me as an entrepreneur through multiple companies.
Great. Hervé.
Yeah, thank you, Bart. So I'm going to take the angle of the opposition between France and the US, and the two aspects of my life. I spent half of my career in France in a large company, Alcatel, and half of my life in the US in a startup company. And across these 30 years, I've been involved in patents all along, and first as an inventor. And you mentioned, yeah, it started in 1984, and I counted last night, or I looked into my notes, and I was involved in 36 original inventions, which gave families of patents. And so it's a big involvement. I think as an inventor, the main reward was maybe the silver medal of Alcatel. And it was funny because in the speech, the CEO said, well, and to the bottom line, it meant $100 million. And I looked at my check and said, not much. So that's maybe a motivation afterwards to move on. But so on the business side, I would say I was starting from a research engineer. At the end, I was leading the research of Alcatel, and I was representing business divisions at the IP division committee of the company. And that was interesting because then it was not so much the inventor aspect, but the management of an IP portfolio, both on a defensive side and an offensive side, and working on what we are doing, the competitors, and so on and so forth. So that was most probably the most interesting part of what I did at Alcatel in terms of IP beyond the role of inventor. Then the second part was in the US with Xterra Communications, because well, I was also for 3 years with Alcatel USA, but starting Xterra was, I think, very important from an IP perspective, because even if I had spent 15 years in a large company, I did realize how important it was to pay attention to the IP right at the start, to do exactly what Brandon described with the engineers and the people. And I think, 15 years later, I still see things very, very important, same as you say. So I think that what I did also more recently in terms of involvement in the patent office and all these things is, I would say, monetization of patent portfolio, selling patents, these kind of things, which in my life has been rather new compared to what I was doing, I would say, in the 80s and the 90s. So I think that it's also something a dimension which is somewhat new for me, but which I think is quite important.
Great. So, pretty good background. You can see that both Hervé and Brendan have got multiple connections into the patent system. So what I thought we'd do is just throw out some topics, sort of start chronologically. Let's start with sort of the patent process, and then we'll get into litigation towards the end, and maybe even into some ideas about reform if we've got any ideas. But let's start, Hervé, with just sort of the patent process. And both of you guys, and I want Brendan to also comment on this. And sometimes, we're lawyers. I'm a patent lawyer, and we sort of have clients, and they sort of, we drag them through this process, this patent application process, and we try to explain, we're going to file this, and then we'll hear back from the patent office in about 3 years. And they go, what? 3 years? Are you kidding me? And then we hear back, and they say, this has nothing to do with my invention. What is this prior art? I don't understand this. And then you send them a bill, and they're all freaked out by the bill because it costs so much. And so now we need to understand from the folks that are actually paying the bills and the inventors, are there any problems with our patent system? And start with Hervé, in terms of efficiency, in terms of your perspective as an inventor in using the patent system, how can it improve?
I attended the whole morning, and I think that in terms of cost, time, efficiency of the process, something I've been missing in the morning is we talked a lot about the US Patent Office. But in fact, for an entrepreneur, today we saw the movie, it's global. And yes, the bills are not cheap, but what's the most important to me is the fact that if you have products who have global applications, then there are so many ramifications that's where the cost is and the complexity is. So obviously, and I've been acting in Europe, I've been acting in the US, and I would say today, I know the drill on both sides pretty well, but my main problem as an entrepreneur, as managing the patent portfolio of a company, is what do I do in foreign countries? I don't have a budget of Apple or Samsung for IP, and how do I manage the money I have? And that's, so the cost of the process, I think the process, and I've experienced Europe and the US, is pretty good. Can be improved, because in fact we say sometimes it's slow, but sometimes we are happy that it's slow. So it's, so overall, I think the process is okay. What I'm really missing, for example, I'm also in telecom. There is a lot of work done on standardization, and it was mentioned at the world level. And ITU, which is part of the UN, is fairly efficient from that point of view. And I would say the World IP Organization is not as successful, I would say. And today, this costs me or us a lot of money. And that's, I think my message is also, because of the global aspect and because we're in the US and we're talking of, the 30,000 companies playing in that role, I think it's important to act globally and to change the systems. I've been involved and I'm in patent processes in Japan, in China. It's,
different.
Very well different. I don't even know what I'm doing. That's sometimes the problem. But it's critical because the two images about the guy who forgot to patent and who then find a copy in Shenzhen. Unfortunately, even if I'm totally aware of what I'm doing and so on, that's kind of the situation where you have the European market, the US market, but China is a very, very different ball game from an IP perspective.
Yeah, Hervé and I talked about this, and I want Brendan to comment on this as well, just general about patent system and his experience. But we're really good about sort of internationalization of standards, but just look at the unified patent system that they're trying to adopt in Europe. I mean, it's taken forever, and they still don't have the language issues figured out. And so this notion, I think Hervé's right, this notion of having sort of a more consistent approach worldwide would be great, but I think it's a massive undertaking. We'll see if it can be done.
For language, standardization
English.
is in English.
English.
And that's it.
We all agree with that? Is that good? English?
But if in countries, in France, you have guys who do translate, but that's all. It's just for, usage in the country.
Yeah. Brendan, what about your experience, your sort of observations about the efficiency of the system, frustrations?
Yeah, I
Remember,
think,
you're talking to your patent lawyer, so you
I
need to be
understand
careful
that,
about what
yeah.
you're saying.
And I think I've been very frustrated with the process, not through my patent attorneys, of course, but just the timing of filings. We've even done the quick file. What do they call it? The
Provisional.
Provisional.
provisional, yes, and 6 months and all that stuff turns into a year and a half to 2 years. We just haven't seen that work. I mean, I think the backlog is still so great that a lot of the patents I had took 4 or 5 years to actually get to completion. And the other thing was the kind of the inconsistency of the examiners. A lot of the examiners on kind of the first run, come with kind of crazy comments, and you look at them and you just kind of throw your hands up in the air. How are we going to get over this misunderstanding of what we're trying to do here? And that was always frustrating to me as an inventor. But really, the timing was really the biggest issue. It's hard to wait 4 or 5 years for a patent to be completed, and that was probably my biggest challenge through the process. Now that I've actually, being involved in some litigation on it, it's really interesting to go back and really think about the importance of those initial sessions that we had when we wrote the patent, the brainstorming sessions with our patent attorneys, and how critical it is for you to have someone that writes the patent properly and to help you with that process. My recent experience with depositions and litigation now showed me just, those choices of language were so key at that time, and I never thought I'd remember them 16 years later, but now that I do, I remember having arguments about whether we should include this or that, and it was just so interesting to me to see that those little minute, word changes that we made had such an impact 16 years later. That was fascinating to go through on the other side.
It's a very detail-oriented business we're in. Yes, one word can make all the difference. So both of you have had experiences in really big companies, small entrepreneurial companies, and even companies that may not consider IP as being central to their strategy. So, Brendan, I'll start with you on this one. Talk a little bit about the difference that you saw between the different companies that you've been involved in, specifically the companies that you've started. When was IP really important? When was it maybe not so important? Or was it always, did you always want to implement a patent program?
Well, maybe just from my background, but it was, for me, starting a company, it was critical. It was one of the key things that we did was go and write 2, 3, or 4 patents and have those in the stable to a primary differentiator that we try to protect up front, and that we use that as something for investors, for our long-term protection, for customers, and for competition. So I may be unusual in that effect, but I would always budget the money to go out and get those patents started through any of the startups that I did. So that was commonplace. Nowadays, as I look for larger companies and the larger companies I've been involved with, patents are more about building this huge empire or portfolio that they can leverage against another company. It's just definitely a whole different game. And writing a patent as an employee of a large company is more about getting the bonus than really about helping the Borg fight against the other Borg. So that's the main difference I've seen along the way.
And then what about your last company? How important, are patents really important to every business, or are there certain businesses where you think it's kind of key to the strategy and others maybe not?
My last company, Ripcode, we developed video processing software for mobile delivery of video. And it was fascinating. We started out, we had several patents in process, but one of our biggest challenges with that company was competing against open source. So we actually saw a large part of our available market kind of dissolve because you could basically for free, as an end user, pick up open source software and use it. And the pressure that we felt, even when we had to develop some things for the open source community, to relinquish our IP rights, a part of that was a real challenge, and it was a real balancing act for us in that company. And I'm never sure we really reconciled that before we sold the company, but it was really fascinating to me how especially as it comes to web-oriented technologies, the quick pace of open source is just really changing the way an entrepreneur may use patents to help his company.
Yeah, it sort of reminds me of Kappa's comments about, you've got sort of balanced proprietary versus the sort of the collaboration sides of the business, and it changes with the different businesses. Hervé, what about Alcatel versus Xterra?
Well, I think the same kind of differences as Brandon mentioned. I think I'll start by Xterra because it was very important at the beginning, as you said, Brandon, with respect to the investors, to really nail the innovation, to really have the differentiator. What I discovered a long time is that, in fact, it has been important all along. That is, obviously, during tough times in terms of cash management, you need to really think through what you've done, what you should do, and that has been very important. And even 15 years later, when people look at you through your patent portfolio, and they still today, you have people who are ready to invest and who go through a due diligence and who ask me questions that have been asked, I would say, 10, 15 years ago. So that's very different from Alcatel, where it was, a big number game, essentially. But here, I would say the quality of the patents and the quality of the portfolio and the management where we want to go and so on is valued. And that's, I would say, very interesting because along the life of the company, you have different aspects, and it's never ending.
Right. So back to this comment that Hervé made about sort of international protection. One of the things when we were talking, getting ready for this, and I think Hervé had a great way of talking about this delocalization of sort of developing products. So you may design, here in Dallas, but your manufacturing facility is in Singapore. Your customers may be all over the world, your distribution networks, you may be resellers, there may be OEMs, there may be collaboration with others. The market, both the upstream and the downstream delivery of products and services is so complex and so delocalized. Is that making it tougher to implement a patent strategy?
In terms of geography, yes, certainly. That is, for a company of the size of Xterra, maintaining the portfolio, let's say, in key European countries, in the US is a must. But then getting beyond is very difficult. When you have products, for example, which are deployed now across 65 countries in the world, you have real issues. So for example, that's one example where I'm slowing down things sometimes, is having the PCT process as long as possible to really see where we have the applications in order to pick the right areas.
So
I've never patented in emerging countries till recently.
Right. So everybody's making the comment that you file in the U.S. and then you go to the PCT and then you can wait up to 30 months to sort of see how it's doing. Maybe even fast track your filing in the U.S., pick the best ones. But so many companies are not filing everywhere. It's just too darn expensive.
It is.
And you just sort of set your chips in the places that you think has the maximum, benefit for the buck that you're spending. What about your views on that, Brendan?
As a startup, I could never afford. We did file some PCTs.
Just a few, yeah.
And they just extended that to 30 months because it didn't.
It was 18 and then 30
Yeah,
for the
18 was
second
never
phase.
long enough for me to figure out whether it'd be worth filing foreign patents as a startup because we may be just at the tail end of development at that standpoint. But we could never afford maybe a couple in a couple of key countries.
And then what do you do with them, right? Now you have a Chinese patent. What do you do with it, right? It's like, okay, this guy has ordered one of each of my products and he's knocking me off like the camper trailer you saw. Now, what do you do with your patent?
Without a real understanding of how that individual country, recognizes patents and the cultural barriers there, I don't know how you can, we tend to look at it as entrepreneurs, though every country must have the same kind of fortitude as far as, protecting IP as others, but that's definitely not the case. I mean, I'm not sure what a Chinese patent's really going to do for anyone unless you're a larger company and can really put the muscle behind it. And
even if, let's say, you have a budget for having an international strategy, the picture is moving so fast. There is for which countries are you going after? That is, do you pick, well, you don't afford where you sell because it would be way too expensive. So do you go after where people are developing, your competitors are changing all the time, every 2 years? Are you going for the headquarters? And so, for example, like Catel, I never patented anything in Finland. So you see, the picture is moving so fast that it's also, I think, something which is a motivation for me to push for something more global in terms of
Right.
patents.
Because your competitors do.
Because if you are very big in the top 50 companies, you can afford
Right.
to have a worldwide production. People like us can't.
Yeah, not only is your supply and distribution chain delocalized, but so is your competitors, and it's changing all the time. So let's move now. That's the patent process. Now let's move to the enforcement mechanism. And it's interesting, Brendan made a comment where he said, I can, these smaller companies, I can hardly afford to file for foreign patents. And then the big question is, can you afford to actually enforce your patents? Because it gets exceedingly expensive. And so Brendan is actually in the trenches right now. He mentioned this. There's a case that's going to trial probably in early October. Brendan's going to be a star witness because he is the story. He's the founder. And so I want to kind of get Brendan to start off kind of a discussion about, is the enforcement mechanism working? And does it make sense to an inventor that, for example, we've got all these cases in the Eastern District of Texas?
Yeah, that's always interesting to understand how that really came about. And I guess, being the first time I've been in front of patent litigation, I'll have to tell you in a month or two when it's complete. It's definitely been an interesting process so far. I've never been deposed in a patent case until just recently, and I was surprised at the depth in how many landmines there were in the process. But I think it's a more pure process for me as an entrepreneur than all the other aspects about it, because you get back to the invention itself, and we can really talk about those dynamics. And I felt much more comfortable in the deposition than I did actually waiting for the patent, once we wrote it, to go through those trials and tribulations of being filed. So
He's a really good witness, you can tell, if he's comfortable in his deposition.
I wasn't comfortable as it, but it was definitely interesting.
Hervé, what about your experience with patent enforcement?
Well, I would say my experience in the U.S. is in East Texas will be in the future, so I don't have experience so far in the past 20 years in the U.S. But I've had one experience in Europe, in Munich, and from what I can tell so far, the German way or the EPO inspiration is very, very rigorous and very strict compared to what I feel so far. And for me, it's just feelings. But it's not so much the judicial system itself, but it's the starting point. It seems very difficult 20 years ago to start a litigation in Munich compared to what it is today. And it has nothing to do with the system, but it has to do with the entrepreneurs like us who have more potential threats than before.
You had mentioned that it's all judge-based trials as opposed to jury-based trials in Munich. And I find it hard to believe that many common juries today would be able to even be caught up in the limited time you're giving in a trial to even understand even the basics of most of these patents out there. I imagine, I think there'd be an advantage to having a very technical judge make the case here as opposed to juries, but maybe I'm just a naive entrepreneur.
So it's interesting, the case that Brendan talks about, almost all the cases that you typically would take to trial, and this one I think is going to go to trial, you do a mock trial, and there are lots of services that do this, and so we've recently done this. In fact, we're concluding it today. And when you look at the jury pool, I mean, it is stunning. We spend all this time, it's probably 2 years of litigating this, where we've done lots of technical analysis, lots of lawyers that really understand the system, really smart people like Brendan giving their testimony. And you have this incredibly complex infringement, validity, all these patents, telecommunications, technology. And then you realize that you're going to try this in front of mostly high school educated people that have no real background in the technology or the law. And it's terrifying. And so that's why we do mock trial after mock trial after mock trial till we finally win a mock trial, then we go to trial. And it is you know, it's an interesting system, and it's certainly different from Germany.
Yeah, because for example, in Germany, I was surprised. At that time, I was leading the optical research of Alcatel, and it was a lawsuit between, I would say, big companies, telecom companies about optical amplification. And my imagination at that time was, okay, researcher won't be involved. And in fact, really the specialists and the inventors were extracted from the lab, and it was a very deep battle. And I don't imagine that with the...
It's very substantive, very down into the details, yeah.
Yeah.
I think mostly what we see, and I mean, you have to present the evidence to sort of meet your burden, and it's got to be in there for the appeal record, et cetera. But I think mostly it's about telling a story, you know, in front of the juries. And I was telling Brendan, he's kind of the story, right? He's the face, he's the founder, and he's the one that's the inventor on a number of the patents. And so it is a different way of presenting. So with your background in the patent system, I'm going to move on to sort of policy things. We heard from Kapos about, and he's very eloquent in the way that he speaks about it. It's like he used to be the patent commissioner or something. But he speaks about the patent system so well and how it's such an engine for innovation. But at the same time, we see lots of non-practicing entities, lots of litigation. It seems like a lot of money being spent. Companies sort of popping up that are sort of taking advantage in terms of being intermediaries, you know, buying and selling patents, a whole cottage industry coming up, companies like RPX and others. And so the question, I'll start with Hervé, is that, are all of these things, NPEs and the patent intermediaries, the patent brokers, and all of this sort of cottage industry that's developing around our patent system, is that good for our system? Is it bad? Is it just a reflection of sort of how the system adjusts over time? What's your view?
So, and I use the term NPE also. I think that it's just a reflection of the time and the economy, and I don't think that it's going to last too long in terms of the NPE. I have faith in what we do in terms of economy, and I don't think it will last so long. It's kind of a theme for a decade, but I'm not sure that we have to change anything. I think it's an economy which I would qualify a bit of false economy with no real ground and value, which may go away.
So for us engineers, it's sort of a transient response as opposed to steady state.
I hope I'm right, but I think that also what was interesting for me is, and you mentioned what I would call insurance policies, you know, RPX and so on, is the positive reaction of what I would consider as an entrepreneur as a negative reaction to our system. And I think that then it's going to go a bit away. It won't be a problem so much a decade from now.
Okay. Brendan, your thoughts? Is it broken?
I think so. You know, you look at David Kapos's video there about spurring innovation. I think it's a threat to that. I mean, you know, it diffuses the power of an individual invention, and it prevents, you know, by blocking all these things together and threatening with the expense it would be to fight something. It makes it more difficult for the individual to patent innovations, and for smaller companies to do the same. So I think it's a threat to the long-term kind of mission of the patent office. So you think there has to be some kind of curb to that, and it's not just a limitless you know, money grab or patent grab to corner the patent market.
Yeah, and I think those are interesting perspectives. I mean, I think a lot of us feel that maybe they're just highlighting sort of points of vulnerability in our system, right? Places where we may need to think about either judicial decisions that sort of properly tune the system, or even patent reform. We've had that over the years. But it is an ongoing debate as to whether, like Kapos mentioned, whether this is just sort of the natural evolution of a patent system, or are we experiencing a really dramatic change? And one of the things that sort of strikes me, I was going to ask him the question, but I just didn't, but which is you've got this rise in litigation that is a percentage of perhaps the patents, and maybe that stayed fairly constant even over a couple of hundred years. But what about the exponential rise in the number of patents being filed? Does that mean we have an exponential rise in the number of litigations filed? And how does the system sort of react to that? And I do think the timing issue, the pace of innovation, at some point there's got to be a disconnect between our patent system and the pace of innovation. So I've got one other thing I want to throw out, and that is, we'll just go around the horn, which is if there's one thing you would want to improve about our patent system, whether it's getting patents or asserting patents, what would it be? I have a feeling I know what Hervé's going to say.
Yeah, because, well, we were talking about NPs, and I was talking about the international aspect of things. I think companies like Xterra, we are not working on all cylinders because we don't have India, we don't have China, and we don't have Japan. And really because of IP issues. So my wish is, for example, all the US system to be focused to have things moving on an international level to facilitate for US companies to have more easily coverage of their inventions worldwide. And then I have another.
Your only wish is for global harmonization of patent.
It's Christmas. It's Christmas. Okay.
Got it.
It is Christmas. But for entrepreneurs, it's more critical for companies of our size than it is for the top 50 companies. Okay. And another aspect, and I said that today because we are in a law school. I've been involved with my engineering school in France, in the US, for entrepreneurship. And I wish that there would be cooperation between School of Engineering and School of Law, because for entrepreneurs, I think that instead of learning things they will learn by doing them, it would be more useful for them to have the basics on IP, rather than, like me and Brandon, be self-made man in IP.
I promise David and Keith, I did not plug Hervé to say that, because that is the whole point of the Sci Center, is to sort of bring all that together so that entrepreneurs do understand about the patent system. How about you, Brendan? What would be a big change you'd want to make?
It's all about speed of getting the patent and ease of use on that front. And I would just try to close my ears and walk away every time I had to wait for that process to go through, because it was the examiner process to me was the most frustrating process I had to go through.
I do think that the system works. I don't think it's broken. I'm going to go ahead and, as a panelist, give you my opinion. I think it's speed, and I think it's credibility. I think if we issue patents that we think are solid patents, and we think we've got a solid system in place, and we're getting rid of meritless cases quickly in the courts, we've got procedures to do that, and I think the system will be fine. I hope so. We had a joke in the office a couple days ago where another 101 case came out, and it's like, all the patents are invalid, let's go home. I don't think it's quite like that. And this system constantly tunes and changes, and I think that's why it's the greatest patent system in the world. All right, so that's all we've got for our comments, and then we take some Q&A if we've got any questions out there. Yes.
Well, I guess it depends on what's disclosed on the registration process. I think we obviously wouldn't want our competitors to know what we're doing in that time period, and it would really depend on me on some of the details of that. It's just, for me, it's these startups that I do, if I'm going to look at them, are typically average of 3 to 4 years. So if the patent's going to come in at the tail end of the startup, then I'm starting to question the worth to me. I'm using it for a different reason up front than I am, really what the patent's designed to do at the end. And that's purely a selfish goal on my part. But 3 to 4 years was just way too long. In some cases, 5 years before the patent was issued.
I mean, you're using patents for marketing, for customers, and for money, right?
Yeah.
Right, exactly. So
And that's before the patent's even been examined at the patent office.
we use the patent as a credibility, as a differentiator. If it's not worth patenting, why would I invest in the company, right? So if I don't have a solid differentiator that is that's more specific enough, I can actually generate several patents off of it. Why would I start the company? So that's a key part of it.
So there is also, we discussed a bit the provisional, and that's a criticism on my part too. A provisional filed by, let's say, it's a U bar. I never saw the difference between that and the final patent.
I never got my money back.
So for me, no. So I
Go
tell
6
you.
months,
So
Not talking about money.
So when it's really critical, and because because the process is long, I did write provisional.
Well, provisional just dies after a year, so you got to do something with it.
No, but so and it's a risk,
Yeah.
and I totally understand it. But time, 4 years, is a big risk also.
Right.
So just a story because about timing. And when I wrote this provisional, and my counsel said, "Well, you take a lot of risk." I say, "I can show you. I've had the patent when I was Alcatel, and I couldn't believe it. Within 24 hours, there was a patent from Alcatel, a patent from NEC, and from Bell Labs on exactly the
All at
same
the same time.
So
Yeah.
I say, I know time."
First to file. Any other questions? Yes. You know what he means by that. So you go into litigation. If you lose, then you pay the other side's fees,
Yeah.
which can be huge.
Yeah. Well, knowing what, in round terms, what the current litigation I'm going through cost the company that's sponsoring it, there's no way as a startup that I could afford that. So unless I was several more years down the road, I mean, we're talking in the tens of millions for litigation on per side. So I mean, that's a huge amount of money, and unless you're a large, mid-sized company or larger, it's hard to afford that. And that's just it's not like it's that difficult of a patent case. I mean, it's not that unusual, but we're talking, you need 10 million to properly prosecute one of these things. And unless you're properly funded for that, I don't know how a startup can go do that.
So you can't pay your own fees, so you really can't pay the fees of the other side either, right?
Yeah, no, I mean, you SOL, I think, if you lost, unless but yeah, it's difficult. I don't know how you get over that as a small company, and.
And that's also the reason when you asked me about when I was thinking about the cost of the first part of the system, I don't think it's expensive compared to any litigation you can be involved in, and that's a bit scary in some way for young companies. And in fact, in the life of Xera, the point where I was, I would say, worried, and which was a test for me of the patent portfolio, is when we started getting commercial success. Because at that time, my thinking was, Alcatel, Nokia Siemens Network, Lucent at that time, if they have looked at our patent portfolio, if we have one witness, we are going to see that very quickly. And 15 years later, we didn't have any letter or anything from the competitors, which was a big reassurance for me on what we did and the way we did it and so on. But nowadays, our life, I think it's not only competitors, it's also what we discussed, other possibilities of litigations.
Right. Other questions? No? Okay. Well, thank you very much. Thank you, Brendan. Thank you, Hervé. Very interesting.